an example in Nigeria. You gave an example. You said we have laws in Nigeria, the laws that are made by the body that is saddled with the responsibility to make laws. What they consider to be appropriate is what the law is. That's what positive law, law school considers to be law. And then you also gave us the class of scholars. That's this class of philosophers. That's Thomas Hobbes, John Austin's, and Skelson as an exponent of positive law school of positive school of thought. Sorry. And then you talk about the historical law school too. You said the historical law school defines law as a product of historic development. It is a law outgrowth from the history of society, the people, rather than something that can be from nowhere. And then you gave us the scholars for the philosophers too. You said Carl von Savary, if I pronounced that right. You said Gustav von Hugo. Those are the exponents. And you also gave us their weaknesses too. And you said the weaknesses for the historical school is a question of how long the people must engage in a practice before it can be recorded as law. So when you spoke about historical law, you said it's basically history, the things that has been happening before and all that. I don't know if I'm able to. And then you also spoke about the realist school of thought and their weaknesses and the class of philosophers for it. You said the realist school of thought is whatever interpretation the court gives, that's what the law is. So they believe that the prophecies of what the court would do are nothing more pretentious. That is what the realistic school of thought is. And then you gave us class of philosophers for it. You said Oliver Wendell Holmes, Jeremy Frank, Carl Wilson. Well, I don't know how to pronounce that. I'm sorry. And then you gave us their weaknesses, and you said it's only focus its attention only on the court system. The court is not established to make law, but to interpret the law. But still, it focuses on the court system. And then you gave us the last one, which was the utilitarian school of thought. You said that it is the view that proper law are those laws which promote the great happiness for the greatest number in the society. They believe that laws are made or enacted by legislations must meet the standard where a law does not satisfy the greatest number. So you spoke about a utilitarian law being the law that favors was the greatest ones, the happiness of the greatest number. You said their weaknesses is the minority may not consider this class of the minority may not be considered in this. And then the class of philosophers, that's the exponent, was Jeremy Bentham, and you said that he believes that pain and pleasure are guiding force for human ability. So, and then we also spoke about the major classifications of law, which you gave us as an assignment for that. And then you said the major classifications of law are common laws and civil laws, common law and equality, basic public and private law, civil and criminal law, substantive and procedural laws, written and unwritten law. Thank you, sir.
All right, Tubi. Now, you said you were nervous. Why are you nervous? Are you afraid of me, or you are afraid of people that could not even speak up to tell us what we did in the last class?
I don't know. Maybe just talking to a larger audience just got me overwhelmed.
Me, Momo.
Yes, sir. Sorry, the internet went out. I didn't hear you.
And so I said, why were you nervous? Was it because you are afraid of me, or you are not sure of what you were saying, or you are afraid of your classmates, those that didn't even know where we stopped in the last class, or what?
Sir, is what was just that talking to a larger audience, number one, and then
You
number two,
you are
and
talking to me alone, not larger audience. Forget larger audience.
okay, sir.
So you don't have any reason, even when you are saying what is not correct, the fact that you could speak up will already made you a winner.
Okay,
So
sir.
don't
Thank you
look
so
at
much, sir.
anybody's face. Is it the people that could not tell us when we stop that you are afraid are the larger people? Anytime you want to speak, speak your mind. I know when you are with your friends now, you will not be nervous. Don't come
Thank you,
here
sir.
and all the things you gave me a very good rundown of what we did in our last class. So what are you afraid of? All right, so thank you very much, Toby, for that. So we will move on. At least I have a confirmation of where we stopped. So that means we looked at the aspect of law. We looked at common law. I mean, look at eternal law, natural law, divine law. Am I correct, Toby?
Yes, sir.
Okay.
Yeah.
Yes,
So
sir.
I think we're supposed to start looking at the major classification, right?
Yes,
Yes,
sir.
sir.
All
Yes,
right.
sir.
From my own mind, it's like we have gone past that place. But since you are saying that that's where we are, you can take it off from there. It's okay. But haven't you received any lecture on common law and civil law before from the other classes you have been joining?
Yes, sir. We've actually gotten lectures on common law and civil law, sir.
Okay. So that means we are referring to everybody on this platform at this time. So, so what we're going to do is going to be more of an interactive class so that we will be able to know the extent, we'll be able to know the extent to which you understood the topics that we treated. So, Pelumi was raising her hand the other time. What do you know about common law? Based on my teaching. So let's have you if you are ready. Yes.
Sir, according to some of your past videos that I watched, I kind of like forgot some, but I know you said common law
No,
is
no, let's wait. Um, no, I'm talking about the class where you were, apart from what you watched. I've taught this class when you were present, isn't it? When members of this class were present, isn't it?
yes, it is, sir.
Can't remember.
Okay, sir. Can I speak
Yes,
about what I know about common? Okay.
continue. Then I will take contributions too from the other individuals that are raising their hands. The purpose
Okay.
of it is for you to know what we're talking about. Yes, go ahead.
Okay, sir. I said that common law is like a legal system in which laws are derived from the customs and norms of the people,
It's not
and it was
it's not like it is. Do you get
it
that?
is the
Okay.
is a legal system in which the laws is derived from the customs and norms of the people, and it was generated from the English people, where they had to like look at the old cases and use it to solve the problems of the new cases or something like that. Yeah. So you also said that it was derived from it was derived it was developed from the King's Bench, and we had three courts, which are the King's Bench, the Court of Common Plea, and the Court of Exchequer. And he said it also brought about the establishment of judicial precedents. And judicial precedents is in the common law, and it also states that whatever decision whatever decision that is being established by the higher courts is binding and must be followed by the lower court. I made mention of the Court of Appeal and the High Court, that if there is a case in the High Court and the people that are involved in that case, they did not agree to the decisions made by the higher court, that if they take the actions they take is like a civil action, in which they don't agree with what the lower court says, then they will go to the higher court, which is the Court of Appeal. So if they go to the Court of Appeal and they still did not get what they want, they go to the Supreme Court, and the Supreme Court is the apex court in Nigeria. Supreme Court is the highest court in Nigeria. Meanwhile, before, it was the Privy Court that was the higher court, but before 1960, before the independence. So after independence, the Supreme Court became the highest court in Nigeria. So if they go to the Supreme Court and the Supreme Court gives their decisions, that decision is the final decision. Like, that's the decision the other courts must follow, or the decision that the people has to accept, because there is no other place they have to go to. Like, that's the final place they can go to. So that's what I understand. Again, you said that if the decisions in the common, your case has to be common, like your case has to be similar to other cases that have been reviewed before in the past. That if your case is not similar to other cases that have been reviewed, that there's you don't have this thing, like you cannot, your case cannot be heard or something like that, Sha.
There will be no remedy.
Yes, there will be no remedy. And the fact that there are similar cases to your case doesn't mean that it is going to be just, or it is going to be fair. That it is going to be just, or it is going to be fair. So I said that is one of the weakness of the common law. That, oh, sorry, you said that somebody asked a question, that where did they get to know the other cases, that the old cases that they have and the solutions to them. And he said that that is one of the that is one of the weaknesses of the common law, that we don't really know how they got their former cases. So
All
I think
right.
that's all I know about the common law.
Yeah, believe me, you have tried. Thank you very much. You got like 80 or 90% of the content of the class. Okay, we're already moving. Olufon, can we hear you?
Good evening, sir.
Good evening.
So I would like to talk about the common law.
Yes, go ahead.
Common law is a legal system that is based on customs and court rulings. So in this aspect of common law, it has to do with the traditions of the people. The traditions of the people are what is majorly considered in the type of law cases that they adjourn. And then common law are in the powers of the judges to create and refine laws which can affect future cases. Is the common law of so common law in this type of law, judges play a very important role in shaping the type of common law in cases whereby I'm so sorry, sir. I'm trying to put myself together. So in cases of common law, the judges are the ones that are the final say. And the common law is based on whatever they say. It's not based on the fact that in civil law, you can you can use the laws of the land, but in common law, it's just based on whatever the judges say. And then common law is also the inspiration for new legislation. Is sometimes the inspiration for new legislation. And it is also applied to situations not covered by statuses. That's what I.
All right, thank you. You still need to study more so that you can have more facts about your submission because you were mixing some things up. Okay? But you tried. Let's have a bio.
Okay, good evening, sir.
Good evening.
Okay, so for common law is an aspect of English law, the received English law from England that we received. And it to simply put, common law is just a law derived from customs that are common among the people of England, hence the term common. So talking about common law is a law that is very, very rigid because it is based on the customs and tradition. It is not a written law, and it is based on decisions that have been previously reached by courts, by superior courts. Also, in common law, inferior courts are duty bound to follow the decisions of the superior court, and common law also is has always proved to be a complete system. Like it always has an answer to your question, even if that answer is that there is no course of action, there is no remedy, but that's at least an answer. So it always has an answer. It is a complete system for common law, and it is also rigid. And because of the rigidity of common law, which simply states that it is the laws that have been established. There is nothing else that can come in place to change the law or to shake the law. For example, if let's say the law states that if you accidentally kill someone's ram, or you steal a ram, yes, and you have to pay the person, you have to pay damages of 10 naira. And that law was established in, let's say, 1860. So as time goes by, now we are in 1900. The price of ram has changed from 10 naira to 20 naira, but common law is still in place. So if you now steal a ram, now the person that you stole, the person bought the ram for 40 naira, but common law states you have to pay 10 naira. That's like a loss to the plaintiff. So because of the rigidity and the unfairness of common law to people, plaintiffs generally, equity was developed. Yes, equity. Equity is just a system that was brought in place because of the unfairness and the rigidity of common law. So equity was formed by the Judicature or Act of 1875 that merged the common law and the equity together. When we're talking about equity, we're talking about the by the Court of Chancery, yes, which are known as the keeper of the king's conscience. Because then people would write petitions to the king, and the king is busy, he can't read all of them. So it's the people, the chancellors, that would read the petitions and look into the pains of the people and give a response to the king. So equity was developed by, and yes, different chancellors in the courts too. So but the downside of equity was that the chancellors would now make laws based on his own conscience. Like what he's feeling at that particular point in time. That is what he believes is right. That's natural justice, is what he will use to make a pronouncement or a judgment. So there is what's it called? So they put in place some maxims of equity, which are like, for example, he who seeks equity must do equity. Equity shall not suffer a wrong to be without remedy. Equality is equity. Delay defeats equity. Equity follows the law. Those maxims of equity to guide them at the Court of Chancery. So basically, now the common law court and equity are together. So common law is a part of judicial precedent, like we said. It is still a system of law that is derived from previous cases. and it is a civil law. It is mostly civil law because it deals with complaints of people. It does not aim to punish, like criminal law. Yes, I think that's all about equity. Yes, and if you go to the common law court, and they'll actually check your case first with common law, and if your case cannot be solved, for instance, the example I gave of the increase in price of RAM, if your case cannot be solved like that, which is actually unfair to you as a plaintiff, then you are directed to the Court of Chancery, which is the equity for your case to be solved. So that's all there is about common law that I know. Thank you.
All right, thank you, Odutayo, right?
Sir.
Yes, that was a good one, and you've covered common law and equity, and I'm satisfied by reason of that. But in all of these, all of you that have spoken, you hammer much on common law, number one. You also looked at common law and equity. Now, what about civil law, at least from our past classes? What can you say about civil law?
Okay, so what I can say about civil law is that civil law is the home of all laws except criminal law. Like, it deals with the rights of the people, like it deals with the rights of people, the rights of organizations, like cases under organizations, like everything under it. It deals with common law, public and private law, substantive, procedural, everything under law, excluding criminal law. As long as it is not talking about punishment, it's not talking about punishment, then it is under civil law. Then it is a legal system which deals with the rules for dealing with rights, duties between individuals, and it is concerned with disputes. It is concerned with disputes within individuals. It can be family disputes, can be about property, it can even be about personal injury as well. Like maybe what happened was like maybe the how will I put it? Like what happened was it actually caused financial loss, or it even caused the damage to the body. Now at the end point of civil law, the end point of the cases under civil law, they are either compensation or they are either compensation or rights. And you gave an example that maybe Mr. A, B, and C signing a land property or something like that. If Mr. B is the one that is supposed to give Mr. C, he has promised Mr. C that is going to give him the land or the goods, and then Mr. A was not like, that I want to buy that same land. It might not be that um Mr. A has a better offer than Mr. C. So he now sold it to Mr. A. So Mr. B is now in court with Mr. C. The judge would either tell Mr. B to compensate Mr. C, or he should tell him to give Mr. C the land, that since he was the first person to ask for it and they've actually agreed on it, then he should give Mr. C the land. And we're also talking about contract law as well. That one is also under civil law, about the breach of contract or lease agreement between a landlord and his tenants. So that's all I know about civil law.
Yes, I agree with you, and that is what civil law is all about. So, by this general summary that has been provided, common law and civil law as a group or put side by side have been explained. And there's nothing more to add. If you want an additional lecture on that, you may look at my other lecture on this same topic. And I also like the way common law and equity was discussed. Like, mainly speaking, what led to the evolution of equity as a system of law was the harshness that was associated with the common law system, which we believe was rigid and did not give room for any form of flexibility in order for justice to be done. And that was what equity as a system of law came to achieve, because as people could not get remedy at common law, they started petitioning the king by writing their petition to the king to see how he could use the power of his office to avail for them. And when the petition became too much for the king to handle, he started directing such petition to the chancellors, who that we have rightly described as clerics or as the keepers of the king's conscience. And then all of these chancellors administer equity based on what they feel, especially on natural justice. And I was glad that even though I did not mention those many principles of equity in the course of my explanation, I think Pelumi, or the person who spoke last, gave examples of the various principles of equity. And those principles were the guiding factor in dealing with cases that were presented at the court of chancery, which was where the chancellors were domiciled, where they serve the king and help the king to administer justice by listening to the petition brought by litigant. And what we also said about equity is that equity means fairness. It means what is just. It means justice and morality, even though we also establish in the course of our class that it is very difficult to determine what is just in some circumstances, because what is just to Mr. A is not what is just to Mr. B. And then sometimes, because the way you look at a thing may make you believe that that thing is right, whereas it's not actually right. So to this end, we did establish that at some point, common law and equity, as a system of law, existed side by side. And then when there are conflicts between them, because of course, when people notice the influx of petition to the king through the chancellor, and that the people got remedy, they had their cases attended to, it created some form of comfort for them, and that led to the avalanche of petitions that were sent to the king. And then it also affected the number of cases received by the common law courts. and then it created some form of tension, which was resolved by the king himself in the Hell of Oxford case, where the king decreed that when there is conflict between common law and equity, that the doctrines of equity will prevail. Of course, that will not be far from the angle that common law is rigid and equity is flexible. Equity is interested in justice being done rather than abiding by a particular pattern or form. So that was one of the things that led to the King James I to give that directive that where there is conflict between the two systems of court, then the doctrines of equity prevail and takes precedence on it. And we also did establish that the Judicature Act of 1873 and 1875 made the common law court and the court of chancery into a single court, and they had the commission, they had the directive, they had the task to administer both the rules of common law and that of the doctrine of equity. So that gave us a summary of what we mean by the classification of common law and equity. Also, in our other classes, we've looked at public and private, isn't it? I mean, public and private law. Now, I also want some members of this class, probably those who have not spoken before, to also speak to that. And let's see how well you fared in understanding this subtopic, public and private law. Do we have people on the floor to interact on this? Yes, Adeleke, Janet, let's have you. All the men in this class, are they sleeping? Adeleke, let's have you.
Hello, sir. Can I talk?
Yes, please, go ahead.
So, in my own understanding, I would say public law governs the relationship between individuals and the state, focusing on issues that affect society as a whole. Do you understand?
Okay, is that all you want to say, Janet?
No. This is not Janet. This is Treasure.
Is that what?
This is not Janet. It's Treasure.
Okay, is that all you want to say?
No. Okay, so I also have.
You can still say more.
Okay, so I also have some points that I actually wrote down. So I have under the public law, I have the constitutional law. So this regulates the structures and affects and functions of government institution. And under it, so I also wrote administrative law. So this governs the action of government agencies. I don't know if that's also correct. So under it, I also have criminal law under the public law. So this addresses offense against the state and prescribes penalties. That's all I think I have to say on public law.
That's beautiful. What about the private law?
The private law, I didn't really get it, but I took out some stuffs, and it's put down that it regulates relationship between private individuals, focusing on personal disputes and transactions.
Okay.
So I
Okay,
also
yes, go ahead.
okay, so I also wrote down key areas on the private law. So we have the contract law, property law, family law. Yes, that's what I wrote down.
Okay. That's okay, that's correct. Samuel, Stephanie, you want to add? I
Yes,
like
sir. Good evening.
yes. Good evening. Speak to public and private law.
Okay, so from what I wrote down and what I can remember, public law is concerned with the protection of the states, right, and the citizens and the organs of the state. Well, public law involves a person, the citizen, and the government in a whole, and not just individual and individual. And it deals with how the society can be properly organized without havoc. It also involves the government. Public law regulates the relationship between a state and the society. Then I also wrote that public law deals with the rights of the state to its citizens and the citizens' rights in a country. Then we have the example of public law. We have the constitutional law that regulates the state in a whole. Then we have the administrative law. I think an example of that can be like our taxes that we pay, our traffic rules and regulations. Then we also have the criminal law, and this has to do with crimes in the society that affect the society in a whole. Then for private law, I think there was one I wrote. Okay, private law is about disputes between individuals, right? And it's not just, it doesn't have anything to do with the state. And private law regulates the rights and duties between private individuals to one another or private individual to an organization. Then an example of private law can be seen in the tort law, the commercial law, law of contract, banking law, land law, family law, and etc. The right of individual within the society is also can also be seen as a private law. Then one distinguishing feature of private law and public law is that public law has to do with a citizen and the state, while private law has to do with the individual to individual or individual to an organization. And that's what I have. So thank
Okay,
you.
you did very well. That's beautiful. Apart from those that are raising their hands,
Hello, sir.
yes, I want you to speak on civil and criminal law. Those who spoke on public and private law got the lecture properly, and then they were able to do a good job with what they said. So let's listen to a recap on civil and criminal law as a class. Anyone?
Okay, good evening, sir.
Yeah, good evening.
Okay, let's start with criminal law. From the term criminal, a crime. A crime is an act or omission that is punishable by the state. Criminal liability arises where there is a breach of the criminal law. So when we're talking about criminal law, we are saying that it is a law that regulates crime in the society, the do's and don'ts of the society. So criminal law actually, the main intention, the main purpose of criminal law is to punish, the is to punish the person that committed the crime. Yes. But in civil law is the law that the law that government conducts, which is generally not punishable by the state. Civil law is just a law that regulates relationship between and members of the society. It is a law that is put in place to settle disputes among members of the society. Civil law does not aim to punish, but rather it seeks to compensate the plaintiff. Now, if we're talking about some major differences between civil law and criminal law, it would be, like I said already, the aim of criminal law is to punish, while the aim of civil law is to compensate the victim. And another difference is that the terminologies used in defending the laws. In civil law, we use plaintiff and defendant. The plaintiff is the victim, while the defendant is the one that has committed the crime. While in criminal law, we use the prosecutor and the accused. That's a terminology. Another important point to consider when we are distinguishing civil and criminal law is that proof. It is proof. When you want to prove that an action is civil and not criminal, for example, say for theft, you have to prove that for criminal law, you have to prove that you have to prove beyond reasonable doubt. Like you have to cross out every possible loopholes. You have to prove that yes, this thing was indeed committed as a crime. It is committed to harm the other person. But for civil cases, you just have to have the balance of evidence or preponderance of evidence, which is the evidence that is more believable. Which of the evidence is more believable? For example, you say you go to somebody's house to steal something. Stealing is defined as taking something without the owner's consent, with the aim to permanently deprive the owner of that particular object. So now you say you stole something from somebody, you go into your friend's house or even a neighbor, and you just carry a TV and you take the TV to your room. And let's say
You carried
you
your
go
TV before?
No, he has not carried. So you just go to the person's house and then you just say your aim was not to permanently rid him of his TV. You just wanted to borrow the TV. So that, in fact, can actually be a criminal or a civil law. But I'm sorry, I am going to digress a little. In the Nigerian society now, I think maybe it's because most people don't recognize their law, or they don't even know the existence of civil law. For example, small issues between you and a neighbor, you quickly go to the police, and once you involve the police in an issue, it becomes criminal. Like the case becomes criminal. That's when you start talking about detaining, arresting people, charging them to court. It is something that if you have a lawyer that can advise you, you can sue for damages. It's not like if somebody steals your car, you charge the person to court, the person goes to prison for 2-3 years. That prison term is actually not going to bring back your car. But if you take the civil route, you can sue the person and collect damages, compensation. An example of civil law is defamation, negligence, law of contracts, those kind of law. Another distinguishable quality or characteristic is that in a civil law, if the plaintiff fails, it will be dismissed. But in a criminal law, if the prosecutor fails, because we established that the terms, we established the terminologies used before, that the plaintiff is civil and the prosecutor is criminal. So if the plaintiff fails in a civil matter, it will be dismissed. The term is dismissed. While if the prosecutor fails in a criminal matter, the accused will be discharged or acquitted. While also where we have terminologies like sue, trial, and liability in civil law, we have terminologies like prosecution, conviction, and sentence in criminal law. And lastly, anybody who wins in a civil matter is entitled to cost. That is either money or they compensate, or even an apology. Yes. But in criminal matters, what you only get at the end of the day is the punishment. It's just punishment. Like there is no other remedy. So that's the distinguishable qualities of civil and criminal law. So to sum it all up, while civil law deals with disputes among individuals of the society, and the aim is not to punish, but rather to enforce order in the society and give compensation to the plaintiff. Criminal law is a law of crime, which aids to punish the offender. Yes, and yeah, that's all I have to say.
Thank you. This is Odutayo, right?
Yes, sir.
Apart from my lectures, which other textbooks have you read?
I used to read about law. Like I used to make research because I used to want to study law before, but unfortunately I couldn't because I got sidetracked by other things. So now, so at least we can study law in mass comm, even if it is just partial.
All right. It's never too late. If you want to study law when you are done with this degree, at least we have people of 65 years that are still in 200 level in law. So age cannot be a barrier. Now, why I asked that question is that I discovered that in addition to the lecture I gave, you already have several other facts which are correct about this classification of law. And I'm very impressed with your performance on this, your submission. As a matter of fact, this class, more than the other ICE classes that I've taught, you've really impressed me, and I want to see this display of excellence in your results when eventually out. Okay, so thank you.
Yeah,
And
thank you, sir.
yeah, so let's move forward. I'm satisfied with the discussion on civil and criminal law as done by the last speaker. Then the next classification is substantive and procedural law. Who is going to speak to us on that? Yes, Odutai, are you raising your hand? Who is going to speak to us on substantive and procedural law?
Okay.
Let's have Otutu, Elizabeth. All the guys in this class are sleeping. They are not here today. It's rather unfortunate. Yes.
Good evening, sir.
Give me.
Yes, sir. According to my understanding, substantive law refers to the actual laws that define rights, duties, and liabilities. It makes us know what people can and cannot do, and also lets us know the penalties for violating those laws. Citizens are required to follow those laws, and if they do not follow those laws, they would get punishment, maybe in fines or maybe by going to jail or compensation. It also includes legal areas like contract law, tort law, criminal law, and constitutional law. For procedural law, it deals with legal processes to enforce substantive law and let us know the steps required to, if we want to, for instance, if we want to initiate legal action, and if we want to present evidence or check out what witnesses have to say or enforce court judgments. Procedural law governs aspects as maybe how a lawsuit or criminal prosecution begins, the process of proving claims in courts. The I can't really remember that, but and also how judgments are delivered and how judgments are enforced.
Beautiful submission. That's very good. Yes, Toby, you want to add to that before we move to the next classification?
Okay, yes, sir. So as you said earlier that as she gave what's the name definitions of the two type of law, I just want to give some key takeaways. So just for us to like understand exactly what she was trying to say. So
You see
substantive
how
laws.
your voice is now, where you were not afraid of your people.
Sir, I'm shy. Okay. So substances law declares money laundering illegal and sets punishments, while procedural law ensures a fair trial, but errors in procedural law leads to convictions being overturned. So if your what's the name? If there's error in you trying to in what's the name? In your submission of trials, if there's error in it, it will not be accepted in the court of law. And then another thing is that both law must work together without substantive law, there would not be crime. Without procedural law, there would not be trial. That's another thing. So I don't know if there's still time. I want to give a real life case on what's the name? If there's still time, I want to give a real life case on what substantive
Stay
law.
close to your mic. Stay close to your mic. You are
Okay,
fine.
sir. Okay, sir. So there's this there was a time like that I think I don't know when it happened, but there was this governor of Abia State that was charged 7.65 billion naira for fraud and money laundering. So the substantive law applied to it was that first thing, the EFCC they were granted power to prosecute financial crimes, their financial crimes, and then the what's the name? The act of money laundering defines that punishment for money laundering, and the criminal code for it defines that a crime. The criminal code was that frauds are a fraud is a crime and it sells penalty. So for punishment for Kalu was that it was sentenced to 12 years imprisonment. So where does the procedural law comes in the appeals for Kalu. Oh, sir, I'm so sorry. I wrote all these things down. This is where procedural law comes in. So the Supreme Court overturned the convictions because the judges lacked jurisdiction, citing procedural violations. That was where the appeal came in. The case was set for a retrial following the appeals. Following the appeals, the procedural rules. I'm so sorry. I don't know why it's all scattered on the table. So what I was trying to just give is that when Kalu was when he had a money laundry of 7.65 billion naira. Normal, what the substantive law would do is that they will charge him to court. That's the normal thing for him to do. Like they gave him 12 years imprisonment. But because there was a procedural rules, they had to give him a retrial on it. And then the retrial worked, and I think he got lesser imprisonment or something. But yeah, that's what just I'm trying to explain. Thank you, sir.
All right. Thank you very much. Well, I think you guys got the gist of this kind of law. And I think from the very first speaker down to Toby now, you're able to simplify it because the two, like somebody said, without the substantive law, there will be no crime. And without the procedural, there will be no punishment. That was a very beautiful submission. So that is how you distinguish between substantive and procedural. The substantive is what is saying, don't do this. It stipulates the actual offenses, like offense of murder, of rape, of harassing, name them, and so on and so forth. Why the procedural talks about procedures that need to engage to prove a particular case. It may even, amount or, have something to do with how you even tender your evidence in court. For example, it is a procedural matter when you are supposed to tender the original of a document and the original is not available. The procedure is that you need to lay a foundation for the absence of the original, and then you make an attempt to tender the photocopy, which is regarded as a secondary evidence. So basically, substantive law, as you rightly said, talks about the actual laying down of law or of offenses or things that should be done or should not be done. So that's good. Is there any other person that wants to contribute to that particular topic before we move to the last classification, which is the written and unwritten law? Favor?
Yes, sir. Give me, sir.
Good evening.
Okay, so what I just want to talk about is the substantive and procedural law. So as I've said, the substantive law is the body of rules or legal rules. It defines a code of conduct, and code of conduct means like a norms or rules set in a particular organization or a society. So this code of conduct, it prescribes a penalty for the violation of that code, which may be in form of compensation, fine, or imprisonment. But that procedural law, it concerns the approaches of how, like, it provides the method and processes required to initiate or bring an action in court. And some of the legal processes, we can say there are classes of legal procedure. One, inquisitorial and adversarial method system. So the adversarial method, the parties and the lawyers have considerable control to decide how cases, witnesses, and evidence are gathered and presented in the court. While the other legal process they can use in the procedural law is inquisitorial method. This inquisitorial method is only the adjudicative body or judge that have the considerable control to tell them how to gather facts or how to present the cases in court. That's also.
Right. Thank you very much. That's also another good contribution to substantive and procedural. I'm glad that you guys are doing well on this. I repeat. Okay. So let's move on to written and unwritten law. Written and unwritten law as a class of law. Okay, let's take Nifemi. Let's take Nifemi.
Good evening, sir.
Good evening.
Yes, sir. Written laws are known as statutory law or codified laws. They refer to laws that are like stated in written documents such as constitutions, statutes, or regulations. They are laws that are created by legislative bodies like parliaments or congresses and are enforced by courts. They provide clear guidelines for behavior and are often supplemented by regulations and interpretative guidelines. Unwritten laws are also known as the customary laws. They are common laws or judge-made laws. They are laws that are not like explicitly stated in written documents, but they are based on customs and traditions or precedents. They are often developed through court decisions where judges interpret and apply general principles to set specific cases. They can even like evolve over time because societal norms and values change. Their differences come from their sources because written laws are created by legislative bodies, while the unwritten ones are developed through judicial decisions and customs. Yes. Thank you. That's all I have to say.
Right. Thank you. Thank you. Oluwape, you want to add something to that?
Yes, what I want to add is that like the difference between written laws and unwritten laws is that written laws are formally written down or recorded in legal documents, and they are like constitutions, statutes, regulations, and also legal codes. While unwritten law, they are not formally written down in any legal documents. They are just based on customs, tradition, and judicial decisions. This written law is practiced in Nigeria, while unwritten law, it can also be called common law or customary law. They are still practiced today in England, and we can also see it's even the same thing. They also practice in Britain as well. So that's what I also to add to it.
All right, thank you.
Sound to say something.
Yes, who wants to say something?
I want to say under unwritten laws.
Okay.
The unwritten laws are therefore classified into two, which are the customary laws and non-customary laws. The customary laws are laws that consist of customs, rules, regulation that is accepted in a community And mostly these kind of laws are in a primitive community where there is no centralized system for the enforcement of rules. And we can also say that it is an obligatory rules. Then the non-customary customary laws, this one deals not just only for the community but the general at large, and it comprises of common laws, which are laws that are developed by the English courts. I'm sure.
All right. Thank
Hello,
you.
can I contribute to one thing, please? Thank you.
Yes.
So, based on the written, I would say when written law provides a clear and structured law legal framework, unwritten law allows for adaptability, reflect societally societal norms and values over time. So that's all I have to say.
Okay, so I would like to also add something to that.
I can't hear anything. I also can't hear anything. Ṣé wọ́n sọ? Am I the only one that can't hear anything?
You're not the only one. I
think
can't
you
also
said
you're not
yourself.
the only one. You're not the only one. You all can't hear.
I think he
I'm
muted
so
himself by
confused.
mistake.
Maybe he's doing something.
Can you hear me?
Yes,
Yes,
sir.
sir.
Yes, sir.
I lost
Yes,
connection
sir.
at some
Yes,
point.
sir.
So my network is not really cooperating this evening. So it was Amarachi that was making a point before I was taking off. And she concluded.
Yes, sir. Should
Okay,
I?
all right. Yes, if you don't mind, let me just hear what you have to say before we close.
Okay, I said the unwritten laws can be classified into two, which are the customary laws and the non-customary laws. The customary laws are laws that consist mainly of customs, rules, and regulation that is accepted in a community. And these laws are mostly in a primitive communities where there is no centralized system for the enforcement of rules, and it's also known as obligatory rules. Then the customary laws are laws that are not just only for a community but the general application at a large. And this court comprises of common laws, which are laws that are developed by the English courts. I'm true.
Okay. All right. That's okay. Thank you very much. I think with your interaction this evening, we have been able to run through the major classification of law. And I have no doubts that you will be able to do justice to this as you have done today if you are called upon anywhere. So by reason of that, the next topic we want to look at is the historical development of the Nigerian legal system. And I know that one way or the other, you must have been taught this. So what I want you to do in preparation for our next class is that I will ask for your coordinator to send me the list of the class members. I'm going to send to you the various subtopics you are going to discuss under this topic that we're going to take in our next class. While I'll wait for the comprehensive list of members, then I think our class is on Friday, I guess. Hello? Can
Yes,
you hear
sir.
me? Yes, we have a class on Friday. So if I can get the list today or tomorrow, I can do the groupings so that I want you to make presentation on the topic that we assign to you so that we can have more like an interactive class so that at least you are able to have a better grasp of what we are talking about. So it's not just me that is talking. Even though I've given lectures on this before, and the lecture is also still available on my YouTube channel, which you can listen to guide your submission on that day. So I will expect your class rep to send that list to me so that we can share the class into that group for the presentation. So just to be able to carry everybody along, nothing more, nothing less, but I will expect that every member of this group should participate. Let me just leave it at that. All right, so we are going to stop here for today. And when we reconvene on Friday, by God's grace, we are going to, take it off from there. Yes, Belumi, you have a question?
Yes, sir. I just wanted to ask that if these common laws, if they are like unwritten laws, then how are they able to know if one case is similar to the former one or not? Like I don't understand that part, sir.
Okay. A case being similar It's a matter of fact. Why customary law or a custom is like a custom that is known already, even though not written. For example, I believe you are a Yoruba person. It is part of our custom. If you want to get married now, if you are not married yet, you want to get married, it is part of our custom or our own customary rules that the husband that want to marry you will bring his family members to come and know your parents. It's not written anywhere, but it is known. Do you understand the message? It is known that that is our custom. And if anything must happen, it must follow that custom. Then, if it relates to issue of how do you determine whether it's similar to another case, or you can see that there are two different issues altogether. One is that it's a custom. One has to do with the fact or the story of a particular case. So it is the story of a particular case that will determine whether it's similar to another case. Are you okay now? Then Adeleke asked on the platform for question that, does the procedural law work for other types of law or only the substantive law? Procedural law work across every law, okay, where it is required for a thing to be done in a particular way or to abide by a particular rule. So it is abiding by the particular rule that brings about the procedure. Do we understand now? Then let me hear you, then we close the class for today. Okay, you're not raising your hands. All right.
Excuse me, sir.
Yes.
Please, I didn't get what you said about the next class, historical. I didn't get that topic.
Yeah, the topic is historical development of Nigerian legal system.
Thank you, sir.
Historical development of Nigerian legal system, and it will lead us to look at the three timelines in our history as a people. So it will include the pre-colonial judicial administration, it will include colonial administration, and lastly, pre-colonial judicial administration. Then we will also, as part of that topic, look at the nature of the Nigerian legal system, which will push us to look at the major characteristics of the Nigerian legal system. So that is going to form the center of our discussion in our next class. So for today, we stop here. And thank you very much for listening, and enjoy the rest of the day. God bless.
Thank you, sir.
Thank you, sir. Thank you, sir.
So that
Please,
man decided to talk now that the class is over. All the ladies have been speaking since morning. Well, like I said, I will take my attendance from the attendance generated by Zoom. So don't worry yourself, okay? Thank you.
All right. Thank you, sir.
Thank you, sir.
Thank you, sir. Bye-bye.
Taile.
Kilele.